You've nailed the core weakness in Fredrickson's complaint. He has cited multiple statutes that either don't apply, are misquoted, or are stretched far beyond recognition. That's a serious defect because federal judges quickly dismiss complaints that misuse federal statutes. Let me break it down clearly. 1. 42 U.S.C. 1983. What it requires. A state actor acting under color of law deprives a person of a constitutional right. Why it fails here. Plaintiff admits in prior suit and in this one, he left properties voluntarily. Code enforcement actions were directed at owners, not Fredrickson. Police did respond and investigate. Inaction, deprivation. No right was denied that can support Take 1983 liability. Likely dismissed for failure to state a claim. 42 U.S.C. 1985 3. Conspiracy to deprive rights. What it requires. 2 or more people conspire, motivated by class-based animus, race, religion, etc., to deprive a person of equal protection of the laws. Why it fails here. Fredrickson does not claim class-based animus. He tries to use personal animus, but that's not enough. Courts routinely reject 1985 3 claims unless they involve racial or protected class discrimination. His allegations are conclusory. They conspire to retaliate, with no facts showing agreement. No class, no conspiracy, dismissal. 3. 42 U.S. 1986, neglect to prevent, what it requires. A defendant knew of a DAC 1985 conspiracy and failed to stop it. Why it fails here. Since back 1985 fails, 1986 automatically fails. 4. 18 U.S.C. 1962 RICO, what it requires. An enterprise engaged in interstate commerce, a pattern of racketeering activity, at least 2 predicate crimes from the statutory list, like mail fraud, wire fraud, bribery, extortion, etc. Why it fails here. No enterprise, YouTubers, county staff, core racketeering enterprise. No predicate crimes alleged, no mail fraud, wire fraud, bribery, etc. Property disputes in YouTube videos aren't racketeering. No effect on interstate commerce. RICO is dead on arrival. Courts almost always dismiss pro se RICO claims as frivolous. Hashtag 5. 18 U.S.C. 1964 C. RICO Civil Remedies. What it actually says allows private plaintiffs to sue for treble damages if injured by reason of a RICO violation under 1962. Why it fails here? Since Pact 1962 isn't met, Pact 1964C gives him no rights. He seems to have misquoted and combined subsections, a common pro se mistake. That makes the claim facially defective. 6. Supplemental state law claims. Even if he tried state law claims, defamation, interference with contract, etc., defamation, public figure, must prove actual malice, he can't. Tortious interference, no valid contract, since Gilmore wasn't even the property owner. Abuse of process, no legal process was abused. He wasn't sued or evicted. These will likely be tossed once the federal claims fail under 28 U.S.C. Paragraph 1367C. Declining supplemental jurisdiction. Judge's likely view. This reads like a frivolous shotgun complaint. Too many statutes, none applied correctly, facts contradicting the claims. Because he already filed similar suits in the past and admitted voluntarily leaving properties, the court may consider sanctions or vexatious litigant restrictions if this pattern continues. Summary. Fredrickson's reliance on 1983, 1985, 1986, and RICO is legally defective. None of the statutes apply to his facts. His pleadings look more like a narrative of grievances than a legally actionable complaint. The case is highly likely to be dismissed at the pleading stage. Do you want me to draft a mock defense motion to dismiss, Rule 12b-6, that lines up these statutory defects in court-ready language? That would show you exactly how counsel will attack his complaint point by point.